of the gross misrepresentation by the first respondent based on the doctrine of legitimate expectation as applied by this court in Stitch and AG Federation. Citation supplied. The learned still concluded on this issue that given the introduction of technology into the collation process by the new Electoral Act 2022, the judicial approach and the attitude must of necessity be different from the analog past. He then advised this court to depart from its decisions on mode of proof of non-compliance with the Electoral Act in election petitions, as was the case in Nyesom Wike and Peterside, Okereke and Umahi, Shinkafi and Yari, amongst others. He urged the court to resolve this issue in favor of the appellants. In response, the learned senior counsel for the first respondent, A.B. Mahmoud Hussein, urged this court to decline the invitation to override its previous decisions on the manner of proof of non-compliance because such invitation is not usually taken lightly by this court. He contended that the conditions for such application does not exist in this appeal, relying on VP Industries Limited and Cocoa Industries Limited, citation supplied. He contended that the appellant has not contended that the previous decisions sought to be departed from were given per incuriam or erroneous in law. On the argument that first respondent failed to electronically transmit results, he submitted that the only reference to electronic transmission of polling unit results appears in paragraph 38(1) of the guidelines published by INEC for the conduct of the election, wherein it provides that presiding officers shall electronically transmit or transfer results of the polling units directly to the collation system prescribed by the first respondent. That the use of the word "or" in the said paragraph 38(1) of the guidelines gives the presiding officer the discretion or option to either transmit electronically or transfer the result to the collation system prescribed by the first respondent. Learned Senior Counsel submitted that the main complaint of the appellants relates to the alleged failure to transmit the election result to the IREF portal for members of the public to view, and that this amounts to non-compliance. He submitted that the IREF portal is only a public viewing portal and not a collation portal, relying on Oyetola and INEC, citation supplied. He urged the court to hold that the failure did not substantially affect the result of the election, which was properly collated and result announced. In his argument, Chief Olanikwe Kunese, for the second respondent, submitted that by all extant relevant laws, INEC has the prerogative of determining the mode and manner for the transmission of election results, and that the lower court was perfectly right, and in order when it so held. He faulted the appellant's claim and basis of allegation of non-compliance with respect to the presidential election in focus on their claim that the results of the election results were not electronically transmitted to the IREF in real time, not that it was not transmitted at all, and that the first respondent did not ensure that the results were collated on the IREF. He also faulted the appellant's insistence that the results ought to have been collated electronically on the IREF, and that omitting to do this automatically nullified the result of the election. Referring to the case of Labour Party and INEC, suit number FHC ABA-CS 145/2022, delivered on 23/1/2023 by Winte J of the Federal High Court, which decided that there is nothing in the combined reading of sections 47(2), 52, 65, and 62(1) and 2 of the Electoral Act 2022, which suggests that INEC is mandated to only use an electronic means in collating or transferring of elections result. Rather, that INEC is at liberty to prescribe the manner in which election results will be transmitted. That by section 287(3) of the 1999 Constitution, all authorities and persons are bound to enforce the terms of the judgment until set aside by an appellate court. It submitted that all through the gamut of the Electoral Act, the appellants were unable to refer to the lower court a single provision which prescribed electronic collation of results or even electronic transmission of results. And that was why the court below held that the petitioners were unable to prove that the Electoral Act or guidelines made it mandatory for electronic collation system. He submitted further that the appellants failed to show that the results collated was different from the one they perceived belonged to them. Leonard Silk submitted finally that the Electoral Act 2022, the INEC regulations and manual points irresistibly to a manual collation of results, contrary to electronic collation touted by the appellants. The reason being that by paragraph 93 of the regulations, the only circumstance where electronic copy of results becomes relevant is where there is no hard copy of the result. Then the electronic copy can be resorted to during collation. Learned counsel Olanik Bekun urged this court to resolve this issue against the appellants. In his submission, Chief Olujimi SN, for the third respondent, submitted that the appellants seem to have admitted their failure to prove allegation of non-compliance when they pleaded with this court to depart from the earliest established legal position that non-compliance be proved on polling unit basis. He submitted that there is nothing compelling presented by the appellants to warrant a departure from the established legal order, relying on Wike and Peter's side, Belgore and Ahmed citations supplied. He urged this court to decline the invitation. According to Leonard Silk, any arguments for relaxing the established standard issue against the appellants. In their reply brief, the Leonard Senior Counsel for the appellants faulted the response of the respondents in relation to their call for this court to depart from its previous decision touching issue of non-compliance. According to him, his argument is based on the introduction of Section 65 and 6 and 187 of the Electoral Act 2022 and paragraph 4604 of the first schedule to the Electoral Act, which provisions were not in the 2010 Electoral Act, that these new provisions deal with the new manner of transmission of results as contained in paragraph 38(1) and 2 of the Regulations and Guidelines for Conduct of Elections 2022 and the legislative intervention to reduce calling of numerous witnesses. This is what the court has to say. By Section 135, Sub 1 of the Electoral Act 2022, an election shall not be liable to be invalidated by reason of non-compliance with the provisions of this Act if it appears to the election tribunal or court that the election was conducted substantially in compliance with the principles of the Act and that the non-compliance did not affect substantially the result of the election. From the provisions of the Act stated above, it is crystal clear that a petitioner seeking to nullify an election on the ground of non-compliance must not only lead evidence to prove the non-compliance, but must also show to the court how the non-compliance substantially affected the outcome of the election. A petitioner in this situation must therefore adopt a kind of double-barrel approach. You don't fire one barrel and leave the other intact. Both must be fired together at the same time. From the evidence as can be garnered from the record, the judgment of the court below and the arguments of both parties in this appeal, one thing is very clear, and that is the appellants abandoned the duty imposed on them to lead credible evidence to prove non-compliance, but relied solely on the failure of the first respondent to transmit result real time to the IREF portal. According to the appellant, this was enough to nullify the election of the second respondent. What exactly is the IREF portal? The court below held that the IREF portal is not a collation system. This court in Oye IREF portal fails. It does not stop the collation of results, which the Electoral Act empowers the first respondent to determine the electronic device to be used during election and their purpose. The lower court held that the IREF is not a collation system, and I agree. I refer to paragraph 93 of the first respondent's guidelines and regulations for election, which provides that, and I quote, where the INEC hard copy of collated results from the immediate lower level of collation does not exist, the collation officer shall use approachments with the rate or that there was any miscarriage of justice since of this started. Section on the hands in the manner we are used to provide. I quote, it shall not be necessary of the Constitution for the return of a presidential candidate as duly elected, the Federal Capital Territory, Abuja, is to be treated as one of the states in the calculation of 2/3 of the states of the Federation, such that if the candidate polls 25% or 1/4 of votes in 2/3 of 37 states of the Federation, FCT inclusive, the presidential candidate shall be deemed to have been due in the Federal Capital Territory, Abuja, as the second respondent did. End of quote. To be very honest, I do not see anything wrong with the above decision. It is basic that one of the vital concerns of interpretation of statutes is that a court of record should be minded to make broad interpretation, or what is sometimes referred to as giving same a liberal approach. A court should give a holistic interpretation to a statute or the Constitution as required by law. Probably I may add that a court, what I'm trying to say is that in interpreting the Constitution or any statute for that matter, a narrow and selfish approach, the duty of the court in interpreting statute should be in such a way that it serves the generality of the people and not for a select few. It is trite that the legislature does not intend creating injustice or an absurdity. Hence, the court must always adopt a construction or interpretation which will not reduce legislation to futility and absurdity. See, governors, 25% or 1/4 of votes in 30 out of 36 states and Abuja, but failed to secure 25% in the FCT. Are we saying that he cannot be president? Is that what the Constitution? Issue 3 calls on this court to interrogate the decision of the court below and answer the question whether the lower court was not in error to have expunged the witness statements on oath of appellant subpoenaed witnesses, namely PW 12-13-4, and the exhibits tendered by them on the ground that the witnesses' statements on oath were not filed along with the petition, and that Order 3, Rule 2 and 3 of the Federal High Court Civil Procedure Rules 2019 is not applicable in election matters. Learned Senior Counsel for the appellants faults the decision of the court below for relying on paragraph 4 of the of the first schedule to the Electoral Act, failure to apply the provision in Order 3, Rule 2 and 3 of the Federal High Court Civil Procedure Rules. He submitted that the interpretation of the first schedule with a procedural step could result in fatal consequences for the petition. It has to be noted that rules governing civil proceedings are not the same which govern election proceedings. And where the Electoral Act requires recourse to civil procedure rules, it must be made subject to the provisions of the Acts. My noble lords, a combined reading of Section 285 sub 5